We've seen an uptick in phone calls regarding cases of sexual harassment recently, and we assume it's because of the heightened awareness in the media. But before you grab your phone, let me explain to you how sexual harassment is handled in the workplace. This heightened awareness is a good thing, as people are becoming legitimately fed up with unacceptable behavior. Sexual harassment is being harassed because of your gender. Some examples of sexual harassment include touching, verbal harassment, or even something as seemingly innocuous as saying, "You look good today," or commenting on how a person smells. By the time we hear from people, it's gotten to the point that employees are in fear of going to work because they know that either a coworker or their boss will engage in inappropriate behavior that will hinder their ability to perform their job. There could also be fear of retaliation for speaking up about sexual harassment or being a whistleblower. To learn more about whistleblower infractions, follow the link here or in the description of this video. In order for an aggrieved employee to file a sexual harassment claim, that employee must file the claim with the Florida Commission on Human Relations and with the Equal Employment Opportunity Commission within a prescribed period. A proper claim is founded upon the provision that all individuals within the state are provided freedom from discrimination because of race, color, religion, sex, national origin, age, handicap, or marital status, and that all persons have a right to protect their interest in personal dignity, to make available to the state their full productive capacities, to secure the state against domestic strife and unrest, to preserve the public safety, health, and general welfare, and to promote the interests, rights, and privileges of individuals within the state. The employer is obligated to remedy the situation, which sometimes means firing the person that is engaging in the harassment or giving the person who's being harassed protection from the situation that they're suffering under. If someone hires an attorney to handle a sexual harassment case, they're looking for monetary damages. It's best to consult an attorney first before the employee takes any action, but if it's too late, they should immediately seek legal counsel after the confrontation. If an employee does not report it to the employer can't do anything about it. There is a lengthy process of paperwork filing, evidence gathering, and appeals, so contacting an attorney sooner than later is a good idea. Under both Florida and federal law, an employee who is subject to sexual harassment is entitled to recover, among other remedies, mental anguish, embarrassment, psychological and psychiatric injuries, emotional pain and suffering, as well as punitive damages and the party's attorney's fees. To discover other reasons why you might need an employment lawyer, follow this link or the link in the description of this video. And if you have any other questions, call Calliope Partners at 877-555-1212.